All right, court calls, cause number CR 20124, State versus Hunter James Huggins. Mr. Huggins, if you'll come forward.
Mr. Huggins, obviously, Mr. President, counsel.
Mr. Huggins, come on up.
We've got a plea agreement with the state.
All right, it's my understanding that there's a plea agreement with the state.
Judge, this court has made the state aware that there is a dishonesty with the court. At this time, we're withdrawing our offer to Mr. Huggins. We would ask that this cause be reset for appropriate amount of time, 2 weeks, whatever time is convenient for Mr. Adams, such we can continue to discuss how to resolve Mr. Huggins' motion at this time.
Mr. Huggins, there's a warrant for your arrest at this time. Okay, the court's going to find your bail to be, has already found your bail to be insufficient based on what I believe to be a fraudulent doctor's note that you provided to the court as to why you missed court on January 26th. So the deputy is going to place you in custody at this time, and we will reset Mr. Huggins' matter. Today is the 4th. Available on March 31st. That'd be our next contested docket.
If Mr. Adams is available with that, Mr. Adams and I can reach an agreement. We'll wait for the court before that. The state's comfortable with that, Judge.
31st is available.
All right, we'll set Mr. Huggins on the state's motion on March 31st. That'll be at 1:30, and that'll be here in the courthouse. Is that all you have, Mr. Adams? Yes, and I hope that you agree that you.
Well, it's I did I know what my article's about.
All right, for the record, this is cause number CR 2018, State versus Nicole Stokes. We're set today for hearing on the state's motion to revoke. What's the announcement?
Judge, we're continuing to work on our plea discussions with the state of Texas. The state of Texas has a material witness that's not available today. We're just gonna ask the court to reset this, maybe even as early as, I'm not sure what's the next available, but for the court's record, the state's recommendation is to plead true to all counts on the motion to adjudicate guilt. 3 years straight probation, probated 10-year TDC sentence, safety as a condition of probation, rest with court for additional time to work out whatever other agreements we might be able to reach on that deal. And again, states need a little bit of time. If they have a witness, they'll need, if we have to have a contested hearing, I think we'll be able to avoid that.
Are you available? Are you available on March 31st?
Yes, Judge, I am.
All right, court will set the motion to revoke for hearing on March 31st.
Also ready on Mr. Willis.
Kendrick Willis, CR 19-211. All right, Mr. Willis is set for docket call today.
Judge, we have a plea offer, which is 10 TDC deferred for 5 years probation, $1,500 fine, balance of his financials. We have an agreement with the state of Texas to accept this, like I was telling the court off the record. Just didn't get the paperwork squared away, that's my responsibility. This avenue is not available today, so we're gonna ask the court to carry this possibly to Tuesday, if that's available next week.
Will you already be here on
I'll
March
already
8th?
be here, I know it's already a busy day. If we can get that squared away, so, and just to let the court know, Mr. Willis has been diligently pursuing throughout the length of this case, rehab through Senate court, and everything that the Senate court's asking, we've been keeping the state involved in that. That's one of the reasons why we have this offer. But I just don't want the court thinking he's been out there not being diligent about handling his addiction and sobriety.
You said offer is 10 pro 10. 10 pro 5.
5.
With treatment or without treatment?
Your Honor, without treatment and received documentation, he's already completed Senate court.
All right, court will reset Mr. Willis then to enter a plea before the court on Tuesday, March 8th at 1:30, and that will be at the Van Zandt County Justice Center.
Yes.
Mr. Stevens, are you ready?
I don't have my paper. What we need is, this is I'm sure, that's what we decided to do.
Dakota Dubose, CR 21-212. Mr. Dubose, if you'll come forward. All right, this is cause number CR 21-212, State versus Dakota Lynn Dubose. Mr. Dubose is set for docket call today. So understanding that Mr. Dubose wants to waive his right to a jury trial and set this to enter a plea before the court. Correct. Mr. Dubose, if you will, I'm going to need to ask you a few questions. So if you'll raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got.
Yes, Your Honor.
All right, you may put your hand down. Your name is Dakota Lynn Dubose, is that right?
Yes, sir.
And Mr. Dubose, do you read, write, and speak English?
Yes, sir.
And I have in my hand a document that's entitled Waiver of Jury Trial. Have you gone over this document with your attorney, Mr. Stevens?
Yes, sir.
Have you read it?
Yes, sir. Yeah, I have.
And do you understand what it says? And do you understand that you have the right to have your case tried before a jury of your peers?
Yes, sir.
Do you understand that you also have the right to waive that jury trial?
Yes, sir.
You understand that once you waive your jury trial, as long as you're waiving it because it's what you want to do, then that trial may not be restored to you if later you change your mind.
Yes, sir.
You understand that? Has anyone threatened, forced, or pressured you to make you feel like you had to waive your right to a jury trial in this case?
No, Your Honor.
And you're asking the court to approve your jury trial and let you enter a plea before the court at a later date?
Yes, sir.
All right, Mr. Stevens, you've explained the waiver of jury trial to Mr. Dubose, and you join him in this request.
Yes, sir.
All right, the court will note that the waiver is also joined by the state as to their right to a jury trial. Court will find that Dakota Lynn Dubose has been admonished as to his right to waive the jury trial. Court finds that he has done so intentionally, knowingly, and voluntarily. Court will approve the waiver of jury trial. We'll set this matter for plea. Do you want to set that for next week, Mr. Stevens?
What day would that be, Judge?
We can either do it Tuesday or Thursday. I'm not sure if you're already here on one or the other.
I am here.
Judge, they would request Thursday, just so we have time to notify his family, that there is going to be a plea. That is advised one more time.
That'll work.
All right, court will set this for next Thursday, March 10th at 1:30, and that'll be at the Van Dyke County Justice Center.
Yes, sir.
Thank you.
Mr. White, are you going to have a plea today? Okay, so you're just waiting on paperwork. Like magic. Has it already been sworn by the clerk? Perfect. All right. Michelle Pointer, If you'll come forward, please. All right, Ms. Pointer, this is cause number CR 1324. You are Michelle Marie Pointer, is that right?
Yes, sir.
Ms. Pointer, if you'll raise your right hand, I'm going to place you under oath. Ms. Pointer, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Ms. Pointer, in this case, the state has filed a motion to revoke your community supervision. And in this case, you are represented by your attorney, Mr. Nolan White. If you feel like you've had enough time to talk about your case with Mr. White, and that you're at the point where you understand everything that is in this motion and you understand what your legal rights are.
Yes, sir.
And is there anything about the paperwork that you've read and signed with Mr. White's assistance that you do not understand?
No.
Mr. White, you believe Ms. Pointer to be competent today?
Your Honor, I believe Ms. Pointer is competent, that she understands the proceedings and the goes to the court, that there's some rights that she had given up. She waived those rights.
Does your client waive the formal reading of the state's motion to revoke?
They do, or she does, Your Honor.
Thank you, sir. All right, Ms. Pointer, you appeared before the court on February 21st of 2017. You pled guilty to the state jail felony offense of possession of a controlled substance, penalty group 1, less than 1 gram. On that date, the court heard the evidence, found that there was sufficient evidence to convict you. The court the court did convict you that day of that offense, and the court sentenced you to 2 years confinement in the state jail. And the court then suspended that sentence and placed you on community supervision for a period of 3 years. And it was during that period of 3 years that the state filed its motion to revoke your community supervision. And in that motion, the state has alleged in 11 separate counts ways that you have violated your community supervision. It's my understanding that you're going to plead true to all counts as alleged in exchange for the state's recommendation that your community supervision be revoked and that you be sentenced to 7 months confinement in the state jail, with you being ordered to pay the balance of your financial obligation. That means your fine, your court costs, your restitution, and you would receive 127 days credit towards that sentence for the time that you spent in jail. Is that your understanding of the plea?
Yes, sir. It's true.
All right, so understanding the plea, then at this time, I want to ask you, Ms. Pointer, how do you plead to counts 1 through 11 as contained in the state's motion? Are those counts true or not true?
True.
And Ms. Pointer, are you pleading true to each of those counts because it is true what's alleged in these counts?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead true to any count today?
No.
All right, the court will accept the defendant's plea of true as to each count. Mr. White, any objection to the state's evidence?
No, we have no objection. With no, I don't know if it's in the actual plea agreement, but as part of the agreement today, we will pay the fine and the main balance for cost, which I believe is $1,500. I will be paying that via the check from my trust account.
Okay, thank you, sir. No, that's not reflected. I do appreciate it.
It's not, that was part of our agreement. I was going to say that was our agreement. Understand this is why.
All right, thank you. All right, Ms. Pointer, based on, well, the court's going to admit the defendant's waiver of rights to plea of true as into evidence, and based on the judicial confession of Ms. Pointer and the state's evidence, the court is going to find that Michelle Marie Pointer has violated the terms and conditions of her community supervision. The court will follow the plea agreement in this case. The court revokes her community supervision, sentences her to 7 months confinement in state jail division of TDC, orders her to pay the balance of her financial obligations pursuant to the agreement. And the court will award her 127 days credit towards her sentence for the time that she has spent in jail on this cause. All right, Ms. Pointer, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with bail. I didn't see it there. She may have it. They probably did. It's probably right there. Is that all you have, Mr. West?
Yes, sir. I think I'm gonna take that judgment over to the clerk's office so I can get paid. I don't know if you trust me with court papers or not.
I trust you. I trust you until you give me a reason not to, but you have done that, so.
I ran out.
I gotta go back.
I ran out. Friday after, I was over to the Wild House. Right now, I filed it. And by the time I got back home, I might leave a message.
You can't think about that. Dylan McPherson. All right, Mr. McPherson, this is cause number CR 1945 and 2018-226. Mr. McPherson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, Your Honor. All right, you can put your hand down. Your name is Dylan Kyle McPherson, is that right? Yes. And Mr. McPherson, in both of these cases, you're represented by your attorney, Mr. Bill Stevens, is that right? Yes, sir. And do you feel like you've had enough time to talk with Mr. Stevens about both of your cases, and you feel like you've had enough time to understand everything that's going on and get answers to all of your legal questions? Yes, sir. Anything that you do not understand about the paperwork that you've read and signed today with Mr. Stevens' assistance? No, sir. Mr. Stevens, do you believe Mr. McPherson to be competent today? Yes. And does he waive the formal reading of the motion to revoke and the motion to adjudicate each cause respectively? Yes. Is it his intent to plead true to all counts in each? Yes, sir. I see here that the plea agreement is on the felony case. Is that Mr. McPherson, upon his plea of true to all counts, the state's recommendation is revocation and 6 years confinement in TDC with the order of paying his financial costs, with him receiving his back time credit of 150 days. And on the misdemeanor offense of assault causes bodily injury, a family member, the recommendation is plead true to the motion to adjudicate. The defendant be convicted today, adjudicated, that his supervision be revoked, punishment 111 days in the Van Zandt County Jail, with him receiving 111 days credit towards that, with him being ordered to pay his court costs. Is that correct?
Yes, sir.
All right, Mr. McPherson, in cause number CR 1945, you appeared before the court on February 26th of 2019. You pled guilty to the second-degree felony offense of burglary of a habitation. Court heard the evidence, convicted you of that offense, and sentenced you to 10 years confinement in the Texas Department of Criminal Justice. Pursuant to the plea agreement, the court then suspended that sentence and placed you on community supervision for a period of 5 years. And then on August 15th of 2018, you appeared before the County Court of Law and Judge Winters, and you pled guilty to the misdemeanor offense of assault causes bodily injury, a Class A misdemeanor. That does bring up a question that I have. I see the judgment says assault causes bodily injury to family member, and the state's motion says assault causes bodily injury misdemeanor. It says level A. It doesn't indicate family member or family violence. Are we certain that the underlying judgment is for family violence? Mr. Stevens, while Ms. Heisel is doing that, I'm going to return to you. This will stay with your client. This is bill of cost. Oh, you'll keep that.
Yes.
Your Honor, the original judgment does deduct me.
All right, so Mr. McPherson, on that misdemeanor offense, you appeared before Judge Winters in the County Court of Law on August 15th, 2000. Well, it wasn't Judge Winters, but it was the County Court of Law on August 15th, 2018. You pled guilty to assault causes bodily injury, family violence, Class A misdemeanor. Court heard the evidence, found there was enough evidence to convict you, but the court followed the plea agreement, deferred a finding of guilt, and placed you on community supervision for a period of 1 year. And it was during each of these community supervision periods that the state filed its motion to revoke and motion to adjudicate you. And you've taken the time to read over those with Mr. Stevens. Is that right? So at this time, Mr. McPherson, I'm going to ask you then as to counts 1 through count 8 in the felony case, are those counts alleged in that motion true or not true? True. And as to the counts alleged in the motion to adjudicate on the assault misdemeanor, how do you plead to counts 1 through 5? True. And are you pleading true to the conduct alleged in each one of these counts, each one of these motions, because the conduct alleged is true? Has anyone threatened, forced, or pressured you to make you feel like you had to plead true to anything in court today? My court will accept Mr. McPherson's pleas of true as to each count and each motion respectively. Mr. Stevens, any objection to the state's evidence through the defendant's waiver of rights and plea of true? No objection. All right, court will admit the defendant's waiver of rights and plea of true to each motion respectively in each cause, and the court will take judicial notice of Mr. McPherson's judicial confession. Anything further from state?
No.
From the defense?
No.
All right, then based on the evidence and the pleas of true, the court will find that Dylan Kyle McPherson has violated the terms and conditions of his community supervision in each cause respectively. The court will follow the plea agreement reached with the state. Court in CR 1945 revokes Mr. McPherson's community supervision, assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, and awards him 150 days credit towards his sentence in that cause for time that he has spent in jail. With regards to 2018-226, the court hereby adjudicates the guilt of Dylan Kyle McPherson on the Class 8 misdemeanor charge of assault causes bodily injury, family violence. Court hereby revokes his community supervision, assesses his punishment at 111 days confinement in the Van Zandt County Jail. Court will award him 111 days credit towards his sentence for the time that he has spent in jail and orders him to pay the balance of his financial obligations. This one has Judge Winters. We did transfer that up though, correct?
Yes.
Mr. McPherson, you can come on forward. We'll get you fingerprinted in just a second. All right, Mr. McPherson, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. When you get out of custody, you're going to need to appear here at the courthouse and speak with the court collections officer about taking care of your fines and court costs. If you don't, then another warrant's going to issue for your arrest and you're going to go back to jail. So you don't want that. We don't want that. So whenever you get out, just come up, we'll set you up with a payment plan and work with you to get it taken care of so you can get everything straightened out. Okay? Step over there with Deputy. Okay.
Miss Miller and I just went in. Judge, she doesn't hear real good, so she may be saying her.
Okay, we may bring her up.
Okay, so
I think I remember her.
yeah, she's an older lady. Just
Ms. Sheryl Miller, if you'll come forward, please. Ms. Chester, we're going to have her slide by you. So come on up. We're going to come all the way up here, Ms. Miller. All right, Ms. Miller, how are you today? You doing okay? All right. This is cause number CR 1864, State versus Sheryl, Deline Miller. Ms. Miller, if you'll raise your right hand for me. Ms. Miller, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Ms. Miller, I see here that we have a motion to revoke your community supervision. And in this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens' representation? You feel like you've had enough time to discuss your case with him and have all of your legal questions answered? Okay. And you've taken the time to read this paperwork today with Mr. Stevens. Is there anything that you don't understand about what you've read and what's going on today? Okay. Do you have any questions that haven't been answered yet that you're curious about?
Judge, I had told her that as much backup credit she has, she will either be sent to TDC and probably process right out. And there's even a possibility she never leaves the county jail with $400,000. And I explained to her that the court had nothing to do with that, that basically you turn her over to the sheriff and the sheriff notifies TDC. I think that's what she just kind of wants you to read.
Okay. And so Mr. Stevens is correct. So if I enter this plea today, you enter this plea and I sign it, then you go back to the jail and the jail sends this information to TDC. And then TDC, they make the determination when they're going to pick you up or if they're going to pick you up. They may communicate to the sheriff to send the paperwork and to release you, or they may say, we're going to come and pick her up. And they may take you down to their facility and then process you in. And then once they get the paperwork, then they make the decision as to what happens to you once they get this.
Where?
Yeah, where you go and if you go and how you go. Right. So that's at this point, once I sign and send you back, then you become the responsibility of TDC and they make that decision. And so there's no way for me to say, oh, it has to be done at this time by this day, or you can't take Miss Miller, or you have to take Miss Miller. It's going to be up to their it's going to be up to them completely. Yeah. Any other questions? Any other thing you're curious about? Yeah, that's the same thing. As soon as the paperwork goes over there, they're going to send it to TDC, and then TDC schedules that. They, as Mr. Stevens said, if they release you from custody, then they don't have to schedule to pick you up. If they want to bring you down and process you down in their facility and then release you or keep you or whatever they want to do, then they're going to really be the ones that sets that schedule. We don't set it for them. They tell us when they have the availability to pick you up. Mm-hmm. Whenever TDC picks you up, if they pick you up, then you'll go down to our processing center, and at that processing center, they'll decide where you go. At that time, you could make that request to them.
For the record, Jordan, I also explained this.
Sure. Okay, good. Anything else? Okay. All right, so I see here that Ms. Miller, you're going to plead true to the allegations alleged in the motion to revoke your community supervision, and the state's recommending that your community supervision be revoked and that you be sentenced to 5 years confinement in TDC with being ordered to pay your court costs, and you would have 490 days credit towards that sentence. Is that your understanding of the plea agreement? And Mr. Stevens, do you believe Ms. Miller is competent today?
Yes, sir.
And does she intend to waive the formal reading, or does she waive the formal reading of the state's motion? And is it her intent to plead true to all counts?
Yes, sir.
Okay. All right. So Ms. Miller, it appears that you appeared before this court on June 28th of 2018. You pled guilty to the 3rd-degree felony offense of driving while intoxicated. The court heard the evidence, found there was enough evidence to convict you of that offense. The court did convict you of that offense, and the court assessed your sentence at 10 years confinement in TDC. And then the court suspended that sentence pursuant to a plea agreement that you reached at that time on that day. And the court then placed you on community supervision for 10 years. And it was during your community supervision that the state filed this motion to revoke And they've alleged in 11 separate counts ways that they're alleging that you violated your community supervision. So understanding that, Ms. Miller, at this time, I'm going to ask, how do you plead to counts 1 through 11 in the state's motion? Well, do you plead, are those counts true or not true? They're true. So everything that you read in here on each one of these counts, what they said about you and what you did during your community supervision is true. Okay. Has anyone threatened you, forced you, or pressured you to make you feel like you had to plead true to anything? Okay. All right. The court will accept Ms. Miller's pleas of true to each count. Mr. Stevens, any objection to the defendant's waiver of rights and plea of true?
No.
All right. The court will admit the evidence, admit the defendant's waiver. Plea of true into evidence. The court will take judicial notice of Ms. Miller's judicial confession. Is there anything further from the state?
No.
From the defense?
No.
All right, Ms. Miller, then, based on your plea of true and the evidence, the court will find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement that you've reached with the state. The court hereby revokes your community supervision, assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice. The court orders you to pay the remaining $135 of your court costs, and the court will award you 490 days credit towards your sentence for the time that you have spent in jail on this cause. And you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And part of him carrying that out will be, he will be sending your paperwork to TDC so that they can start determining if they're going to pick you up, and if they do, when they're going to pick you up and where they're going to put you. Okay. All right. So I'm going to have you step over here with Deputy Phillips, and he's going to get a fingerprint from you. Yes. Thank you, Mr. Stevens. Appreciate you getting here and helping us make up last day.
How far was
Ice day last week and 70 degrees this week. I love it. No, you, no, you may not. That's completely denied.
Okay, here's 30, I'm out.
Read your motion again.
Judge, I respectfully like to interrupt and have some good news for the court. I just want to check.
Oh,
in.
in that case, yeah, bring it.
Susan Murray has completed her last probation condition check, and we'll have you on Monday of this week. And it's CR 19-00024. Do I need to file a motion to discharge?
No, if she's completed the terms of her community supervision, then the community supervision office will process that and they'll forward it to the court. You can bring it to their attention if you want to expedite that. Otherwise, they routinely bring that to me off the bench and tell me when they've completed.
We don't get a lot of good news, so I'm going to share.
That is good news. That's great news. You too. Ms. Chester, are you ready? Yes, just have Ms. Haber.
And Ms. Sherwood and Simmons.
Brittany Sherwood. All right, this is cause number CR 21270, State of Texas versus Brittany Dawn Sherwood. Ms. Sherwood, if you will, raise your right hand. I will place you under oath. Ms. Sherwood, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand out. Ms. Sherwood, in this case, you are represented by your attorney, Ms. Casey Chester. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss the case with her and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes.
And Ms. Chester, do you believe that Ms. Sherwood is competent today?
I do.
And does she waive the formal reading of the state's motion to revoke?
We would, Your
Is it her intent to plead true to sole count one?
yes.
And I see that the proposed plea agreement is that upon that plea of true, the state's recommending revocation and 9 months confinement in the state jail division of TDC, along with the balance of her fine and court costs, with her receiving 219 days credit towards her sentence.
That's correct, that's correct.
And Ms. Sherwood, is that your understanding of the plea
Yes.
also? All right, Ms. Sherwood, you appeared before the court on August 12th, 2021 on the charge of abandoning or endangering a child with potential knowing reckless or criminal negligence, a state jail felony. The court heard the evidence, found there was sufficient evidence to convict you of that offense. The court assessed your punishment, convicted you and assessed your punishment at 2 years confinement in the state jail division of TDC. But on that date, the court followed the plea agreement in your case and suspended that sentence and placed you on community supervision for 2 years. And it was during that period of community supervision that the state has filed this motion to revoke and alleged in a sole count of conduct they believe constitutes a violation of your community supervision. So having waived the formal reading of that, and you understand the plea agreement in this case, at this time, Ms. Sherwood, I'm going to ask you, how do you plead to count one as alleged? Is that count one true or not true?
True.
Are you pleading true to that count because the conduct alleged is true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true today?
Yes, sir.
All right, court will accept Ms. Sherwood's plea of true to count one. Ms. Chester, any objection to the defendant's waiver of rights to plea of true into the evidence?
No objection, Your Honor.
Court will admit the defendant's waiver of rights to plead true into evidence. The court will take judicial notice of Ms. Sherwood's judicial confession. Anything further from the state? From the defense? All right, Ms. Sherwood, you hereby remanded to the custody of the Van Zandt County Sheriff, so we can carry out the terms and conditions of the sentence. I'm going to have you step over here with my deputy to be fingerprinted. Good luck to you. Do you have your pink sheet on that? Are you retained on this one? You want to turn one in today, or you can e-file it later if you want. If not, we can get you some. We can get you that way. You can get it done. You don't worry about it. Erica Simmons. All right, this is cause number CR 1661, State of Texas versus Erica Courtney Simmons. Ms. Simmons, if you'll raise your right hand. Simmons, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Ms. Simmons, in this case, you're represented by your attorney, Ms. Casey Chester. Are you pleased with her representation?
Yes.
Do you feel like you've had enough time to discuss the case with her and have all of your legal questions answered?
Yes.
Is there anything about this paperwork that you've read and signed with her that you do not understand?
No.
And Ms. Chester, have you explained all the documents to Ms. Simmons and gone over the case with her?
I have to.
And do you believe that she understands all of her legal rights? And do you believe her to be competent today?
Yes, it is.
And does your client waive the formal reading of the state's motion to revoke?
We would agree.
And does she intend to plead true to all 16 counts as alleged?
That is correct, but my DA before, but all the clients that we have received some of the funds, so she just has additional clients that she's having to pay, but yeah, she's.
All right, Ms. Simmons, you appeared before the court on May 17th of 2016 Court heard the evidence as to the charge of driving while intoxicated with a child under 15 years of age, a state jail felony. Court heard the evidence, followed the plea agreement you reached that day, convicted you of that offense, and sentenced you to 2 years confinement in state jail, along with a $2,000 fine. Court suspended that sentence and placed you on community supervision for 4 years, and it was during that period that the state filed its motion to revoke and alleged 16 various ways that you violated the terms and conditions of your community supervision. Having waived the formal reading of the motion to revoke and understanding what the plea agreement is, at this time in sentence, how do you plead to counts 1 through 16? Are those counts true or not true?
True.
And are you pleading true to each one of these counts because the conduct alleged is true?
Yes.
And has anyone threatened, forced, or pressured you to plead true to any of these counts?
No.
Court will accept the defendant's plea of true as to each count contained in the state's motion. And Ms. Chester, any objection to the state's evidence, which is the defendant's waiver of rights and plea of true?
No objection.
All right, evidence is admitted, and the court does take judicial notice of Ms. Simmons' judicial confession. Anything further from the state?
Yes, Your Honor. I just wanted to make the court aware that Ms. Simmons, through her attorney, has presented the state with evidence of several programs and classes that Ms. Simmons has taken upon herself to complete. She did have a large number of violations while on probation, but since that time, she has completed multiple classes on her own volition without our asking, as well as the Genesis Center program. We just wanted to make the court aware of that for the reasoning for today's plea offer, given the number of violations.
So due to her continued work outside of probation or even in probation, that's what has resulted in the recommendation from the state.
That's correct, Your Honor. We wish her continued success when she's finished serving her sentence.
Anything further from the defense?
The defense, Your Honor.
All right, Ms. Simmons, based on your pleas of true and the evidence presented, the court will find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement you've reached with the state. The court hereby revokes your community supervision, assesses your punishment at 7 months confinement in the state jail division of TDC, orders you to pay the balance of your financial obligations, and awards you 129 days credit towards your sentence for the time that you have spent in jail on this cause. Hereby remanded to the custody of the Manatee County Sheriff so he can carry out the terms and conditions of the sentence. I have you step forward to be fingerprinted with Deputy Phillips. And go up to you. All right, I believe that leaves us with Ms. Chelsea Caver. Do you think a reset to March 31st would be sufficient?
I think so. I just but never got to see from the center, so we just would, so I'm gonna be sending that to the back to my office, hopefully, they got everything ready for.
This is cause number CR 16633, State versus Chelsea Lee Caver. This is on the state's motion to revoke. The state has made a request from the court to continue today's hearing to another date to allow the state to review some medical records that are being provided by the defendant that the state believes touches upon their ability to make a recommendation to the court. Is that correct?
That's correct.
All right, court will reset Ms. Caver's case to allow the state defense to exchange that information. We'll set that March 31st. And that will be at 1:30. And that will be here in the courtroom. If there's an agreement reached before that and you want a hearing quicker than that, you'll just notify the court. All right, I believe that concludes the afternoon docket and all of the cases on the criminal docket. So we will be adjourned. I will see everyone next week.